This is why I say I love the law. Let me explain something to you guys, right? If you are dealing in contracts, there's a reason why I always tell you guys that you need to look at your contract or look under your state law. Because if you look at your contract or you look under state law, you can invalidate almost any contract or an agreement. Okay. Because what these are basically, these are, what do I want to call them? They're templates that are basically handed out. So these agreements are basically, um, they are kind of like standard agreements. So if you agree to the terms in the agreement, then the bank is usually going to create these agreements in their best interest. But if you look on most of your states' guidelines in regards to creating enforceable agreements, you'll find out that most of these agreements are easy to pick through and easy to break because the initial contract was breached by the party who was assuming servicing detail. So look, in section 4, an exact copy of an installment sales contract and any note or notes given in connection with the contract shall be furnished by the seller to the buyer at the time the buyer signs the contract. The buyer's copy of the contract shall contain the signature of the seller, identical with the signature on the original contract. No contract shall be signed in blank except that a detailed description of the motor vehicle, including the serial number or other identifying marks of the vehicle sold, which are not available at the time of execution of the contract, may be filed in before may be filled in before the final delivery of the motor vehicle. Now, what they're basically saying is for it to be a valid agreement, the seller must sign and the buyer must sign. If you receive an installment agreement and the seller doesn't sign, it's not valid. Okay. Even if they assign it, all parties still have to agree. You see what I'm saying? So when you get into these agreements, you have to understand that the seller must sign it. Now, who is the seller? Here's where all installment agreements fall apart. If the seller sells a vehicle which they do not have an ownership stake in, that can cause a challenge by the buyer. Because if you're selling goods that you do not own, then it can be easily challenged. Okay. Uh, all right. I'm going to bring up something else to kind of show you what's needed. Okay. So this is what's needed for any of these contracts to be enforceable. A term which measures the quantity by the output of the seller or the requirements of the buyer means such an actual output or requirements as may occur in good faith, except that no quantity unreasonably disappropriate to any stated estimate or the absence of a stated estimate to any normal or otherwise comparable prior output or requirements may be tendered or demanded. A lawful agreement by either the seller or the buyer for exclusive dealing in the kind of goods concerned imposes, unless otherwise agreed, an obligation by the seller to use best efforts to supply the goods, and by the buyer to use its best efforts to promote their sale. Now, when we're talking about things like assigning agreements and contracts and these things, this is what most people have to understand, that almost all contracts can or are assignable. Okay. Now, there are some contracts to where you can only assign it to the seller or you can only assign it to the servicer, but most contracts can be assigned to almost anyone. Okay, but you have to understand what are the guidelines that dictate an assignment or what allows an assignment to be legal or illegal. So when we understand that, we have to get into this. All assignments must be done by notice. Okay. So the customer is authorized to pay the assigner until the customer receives notification of assignment of rights to payment pursuant to consumer credit transaction. And that payment is to be made to the assignee. A notification which does not reasonably identify the rights assigned is ineffective. What? Listen to what I just said. Okay, I'm gonna walk it back again. I'm gonna Michael Jackson moonwalk this back again for you. He. All right. The customer is authorized to pay the assigner until the customer receives notification of an assignment of assignment of rights to payment pursuant to a consumer credit transaction. And that payment is to be made to the assignee. A notification which does not reasonably identify the rights assigned is ineffective. Okay, so they must tell what rights they're assigning. They must tell, they must disclose that to you before they're able to endorse or sign over anything. Okay, if requested by the customer, the assignee must seasonably furnish reasonable proof that the assignment has been made, and unless the assignee does so, the customer may pay the assignor. Okay. Two, the notification of the assignment shall be in writing and addressed to the customer at the customer's address as stated in the contract, shall be accompanied by a copy of the contract or shall identify the contract, describe the goods or services, state the name of the assigner and the customer, the name and address of the assignee, the number, amount, and due dates or periods of the payments scheduled to repay the indebtedness, and except in the case of a transaction secured by a first lien mortgage or equivalent security interest for the purpose of the acquisition of dwelling, the total of payments, a provision in the assigned contract that the customer waives or will not assert claims or defenses against the assignee. Okay. So when you go through here, see an agreement by the customer not to assert against an assignee a claim or defense arising from a consumer credit transaction is enforceable only by an assignee not related to the assigner who acquires the customer's contract in good faith and for value, who gives the customer notice of the assignment provided in subsection 422.409, and who, within 12 months after mailing of the notice of assignment, has not received notice of the customer's claims and defenses. See, you didn't even know that when they assign your contract, there's a certain time that you have to give them a notice of their claims and defenses. So I'm not gonna go through all this, but I'm telling y'all that most of y'all don't even understand that your remedy is in your state law. And as I always say, stay away from that chicken fried remedies. It's right there how you invalidate your contract. It's right there how you invalidate an assignment, an unlawful assignment. But I'm out.